All rise. The Honorable, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state in this honorable court. Be seated.
Well, good morning, and welcome to today's oral arguments before the North Carolina Court of Appeals as we sit in session here at North Carolina Central University School of Law in Durham. I'm Judge Toby Hanson. To my right is Judge Fred Gore. To my left is Judge Jefferson Griffith. Before we hear argument, I would like to thank Dean Timmons Goodson and her team for inviting us to sit here at the law school and for all the preparations required to make today happen. And thank you to our honorary bailiff for the day. I would also like to thank everyone at the Court of Appeals who work to take our show on the road here, including my staff, the clerk's office, staff counsel's office, and particularly our court security officer, Deputy Marshal Richard Remillard. Further thanks goes to the attorneys and the parties for being here and their participation in this session of court. We do have two matters before the court today. We'll hear them in the order they appear on the calendar. In between, we'll sit at ease to allow the attorneys to switch over, and if anybody needs to leave and readjust in between the arguments. I should also note, if anybody wants to take notes on, for class purposes or that kind of thing on laptops, that's acceptable today. I believe that after arguments and at the end of our session, we will be available for a question and answer session to answer questions from the students, probably not the lawyers.
Yeah, we haven't it up until the morning to ask questions.
Our first case is COA 23358, State v. Davidson. If the parties are ready to proceed, we'll hear from the appellant.
Good morning. May it please the court, I'm Catherine Vandenberg of the Appellate Defender's Office, here for Mr. Davidson. I'll reserve 5 minutes for rebuttal. Two juries who heard this case declared that they could not reach a verdict. The jury in this trial sent 3 notes indicating that they could not agree. They told the judge there was one holdout juror who was voted not guilty on the murder charge. The judge's response included speaking to the holdout juror individually in chambers without counsel present, going beyond the questions agreed upon by the parties, encouraging the juror to continue deliberating, and then not fully revealing to the parties what was said in chambers. This conduct was coercive and unlawful in multiple ways. As argued in the brief, Jamil Davidson's conviction should be overturned because the totality of evidence was insubstantial and the search warrant affidavit contained misleading information. I'm glad to answer questions on those issues, but I'd like to focus this morning on the jury issue because the claims are fairly complex. In the juror claim, there are multiple bases for ordering a new trial. There are some discrete constitutional and statutory violations, and then there's an overall coercive circumstances claim under State versus Roberts.
So one of the sort of prerequisite issues, though, in the case is an issue of whether this argument's really even preserved, given defense counsel's maybe not agreement, but sort of going along with the trial judge's process, sort of at each stage of these issues, including allowing the trial judge to conduct this in-camera discussion with the juror.
Mm-hmm. Correct. So some of the claims, and I can get to each one of them, are not waivable because they're fundamental constitutional claims. And more broadly, if we focus in particular on the judge's meeting with the juror, and I believe it's transcript page 591, 92, 93, the parties had agreed that the judge was only going to ask the juror if she was incapacitated physically, if she was sick or there was some reason outside of disagreement with the other jurors that would allow them to remove her from the jury under the new statute that allows jurors to be removed during deliberations. And the judge went beyond that, and he spoke to the juror and encouraged her to continue
So
deliberating.
what, if anything, was inappropriate about the actual conversation they had?
I was just saying he was encouraging the juror to continue deliberating, and under our Constitution, the state Constitution, you cannot give any sort of instruction to a juror alone. It doesn't matter who agrees to it. It's part of a unanimous jury verdict.
I guess, counsel, is there a discussion where that is non-waivable at all? Because when you look at the conversation from defense counsel, in essence, acquiescing, you know, Judge, I trust you, I trust the record, you know, almost waving the flag and say, hey, I'm okay. Is that non-waivable or is it waivable?
Well, it's non-waivable under a couple of the claims, and it is waivable under some of the other claims, which I can specify. But the bigger point is that what defense counsel agreed to was very limited, and I've set that out in the brief and the transcript. You know, they said only ask her if it's a physical or a mental problem that is causing her to want to get off the jury. And the judge went beyond that. If you look at the transcript, she answers the question, you know, is it physical, is it mental? She says it's mental, and she starts telling him, I'm a holdout juror, and, you know, I'm tired of people bothering me and trying to change my mind when my mind is made up. And that should have been the end of the discussion. And so what defense counsel, if they waived anything, or if they were able to waive it, what they waived was allowing the judge to ask one specific question to determine whether the juror was incapacitated.
Where does that slippery slope stop?
Well,
If one is waived, then where does the slippery slope stop?
I would say, if you look at the transcript,
Well, give me, not necessarily the transcript, give me, I saw the case that you have assigned to that issue.
Oh, okay.
Give me a case that says that one more question is allowed, or the scope of the additional requirements.
Okay. So, under the Sixth Amendment and North Carolina constitutional right to counsel at a critical stage, which is the first claim, waiver has to be knowing. That's State versus Colbert, and you can't waive what you don't know has happened. So, defense counsel didn't know that the judge had gone on and instructed this juror and discussed more with her because the judge didn't report back and didn't, you know, give them a transcription of what had happened.
Was there anything inconsistent with what happened in chambers with the jury instructions that were given to the whole panel?
Well, he encouraged a single juror
He gave him Allen charge too as well, didn't he?
Well, he gave part of an Allen charge, and that's one of the other claims, is that if you give the Allen charge under Williams, you have to give the essence of the whole thing. It doesn't have to be word for word. And he gave the part that encouraged her to keep going. You know, this may be frustrating, but I want you to reach a verdict and, you know, keep an open mind. And he told that to one juror. He didn't tell that to all 12. You know, why should the other jurors?
Is that inconsistent with what he told the whole panel?
Yes, because he didn't include the part about, holding to your individual judgment.
So you're saying she didn't hear the instructions to the whole panel either?
She probably did, but he told her when he pulled her out separately, just the first part of the Allen charge. And I contend that's a huge problem. Not only because she was off by herself and the whole circumstances of that are very unusual and coercive, but also because of the content of what he said to her.
Because in the in-camera discussion, you have the trial judge, a bailiff, and the court reporter.
Correct. So counsel was missing from that, and that's the Sixth Amendment claim. Under chronic, the test is it a critical stage of trial? And I didn't find any case that said, this particular type of instruction is a critical stage of trial, but certainly it is. You know, instructing a jury is one of the most important parts of the case. And under the circumstances of this case, this juror was a holdout for many hours, and then this instruction private conference happened, and then 18 minutes later, there's a verdict. So it's very difficult to say that that wasn't a critical juncture in this proceeding. So there's the Sixth Amendment counsel critical stage piece, which is fundamental error that requires reversal. And then there's North Carolina Constitution, Article 1, Section 24, and 15A 1234, which both say you can't instruct a single juror. And State versus Wilson says that is not waivable, and that you review it because it's constitutional error for a harmless error, and the state has the burden to prove beyond a reasonable doubt that it was harmless.
So your argument is that when the judge said to keep deliberating, that was the error.
Correct. And more broadly, the question that was being posed is that the parties were discussing before they met with the juror is, you know, is this a hung jury, right? And the foreman had told him, essentially, it's a hung jury. He said, you know, the first note to the judge at the end of Thursday afternoon said there's one juror, she doesn't want to vote, you know, she doesn't think there's enough evidence to prove he's guilty. So at that point, the judge knew there was a single holdout.
Counsel, and I'm not disagreeing that there's potential for an argument of a critical stage. However, how does the case law balance out with the argument of the Sixth Amendment confrontation for that stage? With our case law that, you know, requires that if you want a specific instruction, and if you don't object to that instruction, it's deemed waived. So how do we, because there's an argument that not asking or not objecting to the instruction that was given, not wanting to be present, is in fact waiving it because you waive the ability to object by not being present.
Right, but counsel didn't hear the instruction that was given, so he
Who
couldn't.
chose not to be present for that instruction?
Well, he didn't agree that there would be an instruction. He agreed that the judge would ask the juror a question. He didn't say, and then you can go on and say whatever you want, and then we'll see what, you know, happens. And that's the point in the conversation between the judge and the juror. When she told him, no, it's not physical, it's on a holdout, that's been the end of the conversation. And then you come back and decide what to do with the parties. And if you instruct the jury one way or another, it has to be with everybody, not just with the single juror. Another error is, under Williams, the partial Allen charge. So under 15A 1235 and State v. Williams, if you give some of the Allen charge, you have to give all of it. And that didn't happen.
So you think that's in substance or form that he gave another Allen charge to this individual juror? That's your position?
Yes. And so those were the discrete sort of three constitutional and statutory problems. And then under State versus Roberts, there's the test which asks, you know, would an individual juror, under the totality of the circumstances of all the deliberations and discussions back and forth, have felt coerced, that the judge was trying to get her to give up her own views and agree with the majority. State versus Roberts is automatically preserved. Says that unanimous verdict is such a fundamental right that it's automatically preserved if a juror feels coerced to go along with the majority rather than to hold on to her views.
To what extent can we kind of, you know, as an appellate court, kind of looking back at the record in kind of retroactive fashion, you know, to what extent are we permitted to weigh the fact that once the jury went back following this exchange. It only took about, like, I think, something like 18 minutes,
18 minutes.
for it to then reach a verdict. Is that something that factors into our analysis? Certainly it couldn't have factored into the trial court's analysis.
Yes, at least one case, and I'm forgetting which one it is, mentioned the fact that the jury took 20 minutes after being somehow coerced, and I can't remember the situation there, and they said that was a clear factor showing prejudice, right? That how could she have had time to really dig back into the evidence and reconsider her position in that short amount of time? And this was shorter than that.
I guess you're saying, I mean, how long did they deliberate in this case?
Well, they started on very briefly Wednesday afternoon, like picked a foreman, and that was it. And then all day Thursday, and then part of Friday.
So you're saying the brevity of the vote after that interaction
It's a factor.
is a factor?
Given especially that the jury was 11-1 at the end of Thursday, and they had already given one deadlock note at that point. And another factor.
What other factors do you have?
In the overall coerciveness, I would say the fact that the jury sent the 3 different notes, that the judge failed to respond to most of them. He responded to the first note with an Allen charge, the full one that's in the statute. But after that, they sent more notes, and he didn't respond. And jurors even spoke out and said, Judge, when are you going to answer our note? Because it really makes a difference to us. And he said, we'll get to that. And he never does give them another Allen charge or talk about it. And the parties are instead talking about whether she's incapacitated and what to do about this new, the statute has been amended now. It used to be if a juror was kicked off of the jury after deliberation started, that was the end of it. And now there's a new statute saying, maybe you can substitute. So the parties and the judge were talking about how in the world do you even know if someone's incapacitated, and how are the mechanics of that, right? And since she wasn't excused, that statute doesn't really come into play here, but that's part of what all the discussions were. But in the meantime, the jury was left with no guidance. We're hung, keep going is the silent message they received. And then when the foreman of the jury was called in separately, which is another issue I could have argued if I wanted to add a 4th one or a 5th, he reported, she has made up her mind and she's tired of being harangued by the other people, and she said we're hung, and the judge hasn't responded, and so her thought is, well, let me just get off of this jury, and that's the foreman's explanation of why she wanted to be released.
It almost sounds like you're arguing something akin to structural error in this case.
Correct.
In that it's something even maybe more than constitutional error. It's sort of like the whole system failed in this trial. Seems to be
right.
The argument as it relates to this juror.
That's the Roberts case. It says it's fundamental, which is structural. I mean, it's not the same word, but that's the point they're getting at. It's like, what's more basic? And I have read a lot of cases in my time, and I've never seen something like this, where a juror is pulled out separately and then given an instruction. And I think part of the reason that happened was because of this new statute, and they were trying to figure out, how do you know, is she a holdout juror, or is there something else wrong, And so that was, I think, why defense counsel said, well, we should ask her if something's wrong. How else are we going to know? And that's where the judge should have stopped, asking the question, hearing the answer, and that's it.
So your factors were that there were notes that weren't responded to.
Correct.
The foreman said they were not able to reach a decision quite yet, or they haven't reached a decision. And what else was it? The brevity of the change in deliberations.
Well, and the trial court talking to a single juror, which is obviously coercive, even as polite as he tried to be.
I have a hard time figuring out how that's obviously coercive.
Because if I'm a juror who's been holding out all this time, and then I get pulled away by myself and told, you really need to keep an open mind, and I know you're frustrated, but, this is hard, but we want to really get a verdict. To me, I don't know what else she takes from that, except you're the one who needs to change your mind, as opposed to instructing all 12 of the jurors, all of you need to work together.
Is there anything inconsistent with what he said with what he told the whole panel?
Well, you asked me that before, and I think I answered yes. He didn't give the full Allen charge, which is, it includes the piece about...
Is there anything he told her wrong?
Yes. Oh, well, incomplete. I think incomplete is wrong, and State versus Williams says incomplete is wrong.
Well, I think what he said was, what the trial judge said was, I'm not trying to make you all reach a verdict, but I am trying to give both sides a fair trial, all right? And I don't want you to comment to this, but I'm sure there's a lot of frustrated people anytime that there is a disagreement as to the facts of something. And it's just easier to sometimes just say, okay, I'm done. And then goes on to say, if the court were to require you to stay, do you think that you could continue to deliberate or continue deliberation with the other jurors with an open mind?
Right. And I mean, they had already said 3 times we can't agree. And she had just finished telling him she's the one, she's the person in the minority. He knows the vote is 11-1. He's known that for a day. And the fact that he's not saying, okay, I see that you're hung. Thank you.
Counsel, on that issue, how does it factor in the notes? Can't deny there were notes, right?
Yeah.
However, we're only talking about, 36-hour, in essence, full day time range, but in a day and a half of deliberation, which is not a full, clock, day clock. However, how does that factor in that it was only a full, in essence, a full day of deliberation and then they send a note? And then if defense counsel was trying to preserve the record for a mistrial, give me a discussion on invited error by not having this in discussion with the juror in counsel's presence, versus saying, Judge, I trust you, I trust the record. There was a lot given up by defense counsel.
That's true.
In light of the fact that the jury had really truly only spent 1 day deliberating. And don't know, but I know our case law says that just 1 day of deliberation is not a long stance of deliberating. So get me where invited error is not part of our discussion, right, in light of the fact that so much objective opportunity was given away by defense counsel in light of the fact that we hadn't been deliberating that long and he should have been trying to preserve the record with him present.
Right. First of all, there is no, time, in the cases, but this was not a long trial. The whole thing was done in a week. There was only a couple days of evidence. There wasn't that much. By the end of the first day, they had already said they were hung. By the middle of Thursday was the first. And they said what they were hung on, and it was that she wasn't convinced beyond a reasonable doubt that he did it. There's not that much to talk about. And after that, they went a whole morning. I mean, that's a long time. And another factor I forgot to mention is that the judge and the lawyers mentioned yelling. Like there's apparently a lot of noise coming from that room. And, they were saying, well, that's not all that unusual, but also it's troubling if you're probably the person being yelled at is, and that's speculating, but, so back to your question, it was a fairly long time, and they reported, 3 different times that they were hung, which is unusual. And
because that's the build-up to me asking the question,
right,
why would defense counsel not want to be present during that inquiry?
That is beyond
that's an interesting question that
yeah,
kind of deserves some attention.
Well, and I went back and read the whole discussion among them to look for that, and it seemed like they were worried she would be embarrassed, or maybe she would be more forthcoming if lawyers weren't there. But that goes back to the inability to waive the fundamental right of, a unanimous jury.
You got about 2.5 minutes before you get into your rebuttal time.
Okay. I want to say also, under the totality of coercive circumstances cases, there's the Gillikin case, which says preserved without objection, and the fact that it is harmless beyond a reasonable doubt standard, and I think we easily reach that. All the other cases talk about even less coercive circumstances, or some of the cases where a single juror is interviewed, it's less of a coercive situation than here. It would be earlier on, they're just asking a 4-minute question. And even those cases get reversed because the courts find, it's hard to measure the effect of talking to one person, and you can't really know what was said within the jury, and so they default to finding harm. And I'll save the rest of my time. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Zachary Dunn. I'm here on behalf of the state. Jamil Davidson stabbed his elderly neighbor, Mr. Gerald Gillespie, to death, and thereafter voiced his desire to purchase a handgun and told witnesses that he needed to leave the state. Law enforcement later found Mr. Gillespie's blood on the top, sides, and bottom of the defendant's shoes. Defendant raises 3 arguments on appeal. Of course, the one motion to dismiss, one argument related to the motion to suppress, and then what's gotten the bulk, if not the entirety, of the conversation here today, which is the jury deliberation issue. So, of course, I'm happy to answer questions on any of the 3 issues, but I will start where the defendant did, which is the jury deliberations, jury notes, those sorts of things. On that point, it's certainly true that having 7 jury notes, and by my count there were 7, is unusual. Really here, though, we're only talking about 2 notes, the 6th and the 7th note. And I will note, defendant, makes some argument that notes were not being responded to. I did want to push back against that a little bit. All but the 6th note were responded to. Some were mundane issues about marking a jury form wrong and needed a new jury form, or requesting photographs, those sorts of things. But the first note that was supposedly not responded to was note 6, which is the one where the foreperson wrote that they could not come to a unanimous verdict, and that one juror is unable to reach a similar conclusion as the rest. But the reason that note was not responded to was because the lawyers and the court were still in conversations about how to respond to that note when the 7th note came out. It's a very fluid conversation. You can see it in the transcript. It runs for nearly 40 pages of the transcript. The court and the counsel, both for the state and the defendant, are really trying to figure out what to do with this note, whether to talk to the foreperson, whether to talk to juror number 6, and really what to do. And then while they were attempting to figure that out, the 7th note comes out, which is the note that was on behalf of juror 6 requesting to be removed. And then from there, of course, everyone agreed that the judge should talk to juror number 6 in chambers, but on the record at the defendant's request, and kind of make an inquiry about her circumstances. Now, the defendant argues that the defense counsel only agreed to a very small selection of questions. Basically, is this a physical, or do you feel physically threatened, or is this a mental issue, and then should have stopped right there. But reviewing the transcript, especially before the in-camera hearing, and seeing what was going on between the lawyers and the trial counsel. This was a really fluid conversation. From my reading, there was no point in which defense counsel said, Your Honor, I'm fine with Your Honor going ahead and talking to this one juror, but you can only ask about physical versus mental, and then you have to stop. That just wasn't part of the conversation. And
Counsel, how do you balance that with the appellant's argument that, there's a statutory scheme of, this critical stage of trial that, that's non-waivable as far as having that reserve, that it violated the defendant's rights? How do you respond to that argument?
well, I would note it's in our brief. Rule 10 requires an objection to any jury instructions, so that would be my first answer. And this is mandatory. That's from Bennett. And it is waivable. Constitutional issues are waivable. So I think the defendant has to go with structural error. And like Your Honor said, whether this is a critical time in the trial such that the defendant couldn't waive not being there. We would argue simply that this isn't a critical stage of the trial. The jury deliberations, of course, attorneys are not allowed to be in jury deliberations. They're not allowed to know the split of votes, anything of that nature until the verdict comes out.
But typically there's a process, though, in terms of jury instructions, right? You sort of have, proposed jury instructions that the trial judge will say, here's what I propose to give. Are there any objections? Are there any proposed jury instructions to be considered? The jury charge is decided, read to the jury. The lawyers are given them an opportunity to object to the extent the jury instructions given were not consistent with those that were agreed to or decided upon. Where does that process occur here?
Well, I think that process did occur before jury deliberations began.
Sure, but in reference to this specific meeting and instruction of this individual juror, where's the proposed jury instruction that the trial judge intended to give? Where's the opportunity then to object to any discrepancies in that instruction?
Two answers to that. The first answer is, that 40 pages of back and forth between the lawyers and the judge, really trying to figure out what to do. Of course, that's not in form or perhaps substance an actual, process of going through jury instructions. But the second answer would be that the trial court didn't instruct juror number 6 during this in-camera hearing. If you look at, it's only 6 or 7 pages, I'm sure Your Honors have read it. But after everybody consents to the judge speaking with the juror on the record but in camera, and the judge asks whether it's a medical issue or a mental issue, the judge doesn't instruct her at all. Looking at page 591, 592, and I think Judge Hanson, you read this out earlier, quote, I'm not trying to make you all reach a verdict, but I'm trying to give both sides a fair trial. And then again, the judge didn't instruct juror number 6, but said, if I required you to deliberate further, would you be able to do that with an open mind? And she said yes. And then, really kind of her own volition, she said, I might just be confused. And then the judge said, well, would it be helpful if I read the jury instructions to you? And she said yes. And then that was basically the end of the conversation in chambers and in camera. And then the judge came back to the lawyers and reread the entirety of the jury instructions to the entire panel. So, if you're in those 6 pages or 8 pages, however long it is, in-camera conversation with juror number 6, I only see the judge asking questions, not instructing the juror. So that kind of bleeds into whether or not this is a critical stage of the trial.
What do we do with the sentence right before that? And I didn't read this either, but we're sort of prefacing that final piece of the discussion. The judge does say, well, it's important that all jurors feel comfortable so that all jurors work together, and you all have apparently reached a unanimous verdict as to one matter. How does that kind of weigh in, particularly when he's now saying, and I'm sure there's a lot of frustrated people anytime that there is a disagreement as to the facts, and it's just easier to sometimes say, okay, I'm done.
I don't think so, Your Honor. I mean, I kind of view that as more of an offhand comment, trying to empathize with her, understand that it's a difficult process, and it is couched between the comments that I'm not trying to make you reach a verdict, and, I don't want to know the numerical split, all those sorts of things. So, I mean, taking that one sentence and saying, well, because he said this one sentence or two sentences or whatever it is, that transformed this into a jury instruction. We don't think is correct, especially in light of, the juror expressing that she was confused and it would help her to hear the jury instructions, and then those were then given to the entire panel.
Do you agree that under sort of general circumstances, it would be error to instruct a single juror alone?
Standing right here, I don't know if I can, give a firm position. I think if portions of a jury charge were given to just a single juror, I think that may be error. Whether or not it's structural error or reversible error is a whole other thing. So yeah, we would say perhaps, but of course that's not the case here. The case here is, the judges, after a very fluid conversation with all the parties, and really taking a lot of the defense counsel's suggestions. At first the idea was that the judge would just speak to the juror off the record, and this isn't verbatim, but the defense counsel says, I trust you. But I know that this should be on the record, so, we would ask that it be on the record, and the judge agreed. He said, yeah, that's fine, we'll bring the court reporter back in there, and so this will be preserved. Really the trial court acquiescing to the defense's suggestions is really all throughout. It's not only that specific point, but for instance on 553, the defense agrees that the court should ask questions of the foreperson, and then that was done. The defense says a couple pages before on 548 that he doesn't want to cause a mistrial and will defer to the court's judgment on how to deal with these notes. So really, permeating this entire discussion is, of course, all parties being very careful, but also the trial judge taking into account what the defense is saying and essentially giving them what they want, which, is a strong argument for invited error.
How do you respond to the appellant's totality of circumstances, factors?
Thank you, Your Honor. I wrote them down. I hope I got all of them, but if I missed one, please let me know. So the first, I think, was that notes were not responded to, so I talked about that earlier. I think every single note was responded to except the 6th, and that's only because the 7th came out and then they had to deal with that. What the foreman said was the second one, saying essentially that they're deadlocked and there's no point in continuing. I mean, that is, I won't say it's significant. It is a piece of evidence that's in there. The foreman did say that. But I think the stronger evidence is not what the foreman said about what juror number 6 was feeling and thinking. The better evidence is what juror number 6 told the judge. So certainly, the foreman had his or her, but I think his view of what was going on in the jury room. But really the better evidence about what juror number 6 was going through was her conversation with the judge, in which she said, that she could continue to deliberate, she could have an open mind, and that she was confused, and having the jury instructions read to her would help her. And talking about the 18 minutes between when this happened and when the jury verdict was reached, that could be contributed to her being confused, then having the jury instructions read to her, and then not being confused anymore. So
from that, you're saying we have no idea what's going on in the jury room.
We have no idea. That's correct. So that's brevity. That was the third. And then talking to a single juror, we've been discussing that, whether or not we don't think it's certainly during jury instructions, and it was consented to by all the parties, and not structural error.
Even if you were to say that it wasn't instruction in camera, was there anything inaccurate stated in that?
We don't think so. Everything that the judge said mirrored what he had told the entire jury. And the jury had received an Allen charge. And so, everything that was said in camera in chambers to juror number 6 was a correct statement of the law, and not improper in any way.
I guess, counsel, my question, the follow-up to that is there's an argument that, I guess, the context of the discussion was not divulged to defense counsel. What's your response to that for defense counsel to be on notice of what was discussed?
Well, it's true that some portions were not, of the notes and of the in-camera review of the jury were not disclosed. For instance, in a note, the foreperson wrote what the split was. That wasn't disclosed. I don't think anybody argues that that's problematic. But I think reading what the judge said after the in-camera review was accurate. He said, he told the parties that, I talked to the juror, it's not physical, and she would like the instructions to be read back. And so I'm going with the consent of the parties, which they did consent. That's what happened. The fact that he did give a word for word or blow by blow recount of what happened in that meeting, we don't think that's significant, and especially because the defendant agreed that this could happen without the parties present.
So is there a need for the judge to recess for the rest of the day and allow defense counsel to have the transcript or have it, I guess, read into the record? Or what's your response to the need of the court to have complete transparency of that?
Our response would be that's certainly not the judge's job to sua sponte do that. It would be an interesting question if the defense, after this in-camera review, said, Your Honor, we would really like to know what happened in that meeting. Could we recess for the day and have that transcribed? It shouldn't take long because it's only 6 pages. And then, what happened there. But that's not what happened. Not only did the defense counsel agree to have this done without the presence of counsel, but after the in-camera review, nothing of substance happened. The trial court said, it's not physical, it's more mental, and she would like the instructions read out to her, and I'm going to do that for the entire jury.
I guess first I should ask sort of the state's position on whether this was somewhat of a unique process.
I would certainly say it's unique. Yeah,
well,
having 7.
And I ask that because certainly in non-capital criminal cases, there's no requirement of full recordation of the proceedings, and you often have unrecorded bench conferences, right, between the judge and trial counsel for the state and the defendant, and then following that, the sort of statutory requirement that the trial judge sort of summarize what happened in that bench conference.
Correct. Yeah.
But then you also have the two adversarial parties who are able to then say, well, judge, this is, well, just to clarify, this is what I heard, that kind of thing. So you can kind of create a record. Here it's a little unique because obviously you do have the recordation of that interview, but you don't have that adversarial process right there in the courtroom, outside the presence of the jury to make sure that everything was done correctly or is reflected accurately. And I guess sort of following up on Judge Gore's question, how does that impact our review here?
I don't think it does. Like I said, certainly this is a unique situation. I think part of the reason that this was dealt with this way was because of the new statute and her being asked to be removed from the jury and whether or not that would be proper under the new statute. Whether it affects Your Honor's analysis, the court's analysis, I don't think so. Although this is a very unique case, We have the complete recordation of what was said between the trial judge and juror number 6. And from our reading, there's no instruction in there at all. It's just questions. And really, those questions got to the heart of the matter. You know, she said she was confused and would like, more jury instruction. So I hope that's responsive to your question. But
So the state's position that because there was a lack of objection post in camera on any subsequent instructions, because your arguments there was no instructions in camera, that it's deemed waive any arguments of what was or wasn't given afterwards.
yeah, that's a hard question because, of course, defense counsel didn't know what was said in chambers, so didn't know the substance of that. I think where it became waived was even before that. It's when both state and the defense agreed that this could happen and could inquire of the juror. And again, I would stress, from our reading of the transcript, there's nothing, no statement by defense counsel saying, we consent to Your Honor asking if it's physical or mental, and then you have to stop. Like we said, it's a very 40-page flowing, fluid conversation, and we think that the trial judge acted appropriately and within the parameters of what the state and the defense agreed to before the in-camera hearing happened, the review of the juror. But so we would say it's waived beforehand.
So if we were to hold that it was actually instruction in the in-camera session, how significant is the subsequent jury instruction to the whole panel?
We think
as a curative remedy.
Right. We would think it's very, very important and would cure anything. If Your Honors were to hold that there was some instruction, it would be essentially those 2 sentences that Judge Hanson read out. The question is whether that was harmful beyond reasonable doubt. We think because, there was already, of course, jury instructions on the front end, there was jury instructions on the back end. Any extra instruction that juror number 6 received would be merely superfluous to what she heard as a member of the full panel both times that the jury instructions were given to the entire panel.
But the Allen charge was given to the full jury before the in-camera meeting with juror 6.
Yes, Your Honor.
Was the Allen charge included in the reread instructions?
I'm not sure. I don't think so, but unfortunately, I apologize, Your Honor. I'm not entirely sure if the Allen charge was reread.
Because it wouldn't have been part of the initial.
Correct. Yeah. Right. But every jury member did hear the Allen charge when it was given to the entire panel. Do you know how much time I have left?
I do. You've got just over 8 minutes.
8 minutes. Okay.
That was math in my head.
Right. Thank you, Your Honor.
Counsel, I have a question as far as it pertains to the search warrant and the interview of the witness and potential capacity argument, whether what was his state of mind when he was interviewed and the accuracy of the statement versus what was put in the search warrant. Can you address that for us?
I can, Your Honor. So this is kind of the second argument in the briefs, the motion to suppress. Another strange thing about this case is that transcription of the interview that Detective Littlejohn had with the witness. I would make a couple of preliminary points on that. It's not an official transcript, and on record page 65, it appears to have been done by a service named SpeakRight, which I'm not personally familiar with. And it is full of omissions. There's asterisks where the software couldn't pick up what was being said. But even taking this interview at face value and what defendant argues that it represents, there are a number of problems with the defendant's argument. First, we know that the detective talked to another person, another witness, forget his first name, but his last name is Phillips, who gave essentially the same information. Now, there was no recording or transcript of that, but the officer's statement in the affidavit was that the information about the robbery, the information about the stabbing, and the information about Mr. I apologize, the defendant wanting to get out of town came from both of those witnesses. During this motion to suppress, the defense never called Detective Littlejohn or any of the other witnesses. So, essentially we have at face value a sworn affidavit from law enforcement saying that this information came from both of them. We also know that there was at least 2 interviews, and I believe of each person, both Simpson and the other gentleman. There was one on the 18th and then another one on the 20th. So, to the extent that the recording or the transcript of this interview did not contain all of the things that were later contained in Detective Littlejohn's affidavit. There's plenty of other opportunity for that to have come out. In the other witness interviews that were not recorded. And I would note, of course, like I said, he was not questioned at the motion to suppress, but also at the trial, Detective Littlejohn testified and no one asked him about this exchange, about the motion to suppress or what the witnesses told him. So we would say...
And there was no objection to the admission of the evidence itself at trial.
That's correct. That was my next point, Your Honor. That this would only be able to be reviewed for plain error because there was no objection at the trial itself when this evidence came in. There is some argument in the briefing about the order itself, the order denying the motion to suppress. It is, it's a page and a couple lines on the second page. It's not very long. We would argue that it's sufficient in and of itself. It makes the findings of fact and conclusions of law that were necessary to rule on the motion to suppress. But as this court has held, even, that correct decisions of a lower court on a motion to suppress will not be disturbed on review simply because an insufficient or superfluous reason is assigned. And that's McKnight from this court. So we would say, even if Your Honors think that, the findings of fact or the conclusions of law could have been more thorough, because of the underlying facts in this case, and, precedent holding that, a ruling on a motion to suppress will not be disturbed, if, there's a correct reason to affirm it, then we would think that, that defeats defendant's argument on that point. I'm happy to answer any of the court's questions, but absent that, I'll rest on the briefing.
Good.
Thank you, Your Honor.
Thank you, counsel. We'll hear from the appellant on rebuttal, and Judge Matt tells me you've got about 6.5 minutes.
Thank you. Very quickly on the motion to suppress, trial court's order, the trial court's order didn't address any of the relevant factual questions, and it didn't address the actual legal question in front of it, as I argued in the brief, and I'm going to spend much more time on that. Back to the jury question, I'd refer the court to the timeline that I attached at the end of the brief in the appendix that goes through, blow by blow, everything that happened, rather than me trying to straighten everything out. I believe that's accurate. Regarding what the parties agreed to just prior to the in-camera conference, the brief on page 27, my initial brief, it's true that there was a lot of discussion about a lot of things leading up to this, but right when they were deciding whether to talk to this juror and who and where, the prosecutor suggested interviewing juror 6 with delicate yes or no questions to clarify whether her request for release was based on physical or mental distress, And the parties then, and the court said, all right, how about if I bring her in and just say, how do you feel? Are you physically able to continue with your deliberations? Are you mentally able? Prosecutor, yes, sir, that makes perfect sense. The court, nothing else. Prosecutor, give her the opportunity, and defense says, I think that's fine, Your Honor. I think it's clear that the only thing that was agreed to, and especially in the context of this is really strange for a judge to pull out a juror, that they were trying to be very careful and say, just ask this one thing, and then that's the end of it. And that is what the judge did not follow, and what defense counsel was not told. If you look at what the judge says to defense counsel, he doesn't report that juror 6 said she was the holdout juror. I mean, that was one of the main topics of discussion. Defense counsel had argued up to that point, if she's a holdout juror, that's the definition of a hung jury, he said to the counsel. And he didn't say, and therefore I make a mistrial motion, which would have been nice, but he was waiting for the court to finally determine what the problem with this juror was.
How do you address then, in light of that discussion, one, the argument from the state that there wasn't an instruction, so if there was more discussed, it was just discussion and not instruction. But then, secondly, if that is the issue and wanting to preserve any appellate rights, is it on the court to say, I'm going to take a recess and spontaneously do that? Or whose shoulders does that fall on? Because I don't see an ineffective assistance of counsel claim in this appeal. So get me, one, addressing the issue of more discussion versus instruction.
Right.
And then get me to whose responsibility was it to perfect the record on that issue.
I think it was absolutely the judge's responsibility. He's the only person in the room who could say what happened. And the defense counsel trusted him. That should be a thing, that we can trust trial judges to tell the truth about what happened, especially in a strange and delicate interaction like this one.
So let me make sure I'm perfecting our record. I'm not the senior judge, but I want to make sure we're accurate in our depiction that saying that the trial judge didn't tell the truth and didn't, say everything that was in there, I think that's a bridge maybe yet too far for you to maybe step on, counsel. So let's make sure we identify the accuracy thereof. I think we're at a good grounds of roads of being able to say, hey, the judge could have gone line by line, but to say that the trial judge was not truthful about it, are we saying that?
I'm saying that if you look at the words that were said in the transcript,
are we saying that it was incomplete or the trial judge was not truthful?
I think it was incomplete, and the parts that the trial judge left out were very important to defense counsel.
Thank you for that
I will say that. Yes. As I was saying, defense counsel had previewed that he would have made a mistrial motion if it was clear that this was a holdout juror. And had the court come back and said, yeah, she confirmed to me she was feeling pressure by everyone else and didn't want to change her mind, just as the foreman had already told them, there would have been a mistrial motion. But the court instead sort of turned it to, and she said she would like to hear the instruction, and so now I'm going to do that, and everyone agrees, and on they go. I already, I think, addressed preservation, and it's in the brief, the different claims and which ones are preserved and which ones are fundamental, and also the waiver shouldn't apply because counsel wasn't told that there was an instruction.
So I go back to the first part of Judge Gore's question there. What is your position, or what statements do you think are instructive out of what he said?
If you look at the Allen charge statute, 15A1235, some of the things that are considered Allen charges, jurors have a duty to consult with one another and deliberate with a view to reaching agreement. That's the substance of what the judge said to the juror. And what he left out was if it can be done without violence to individual judgment, and each juror must decide the case for himself, and no juror should surrender this honest conviction just for the purpose of reaching a verdict. So those are the pieces that weren't there, and the pieces that were there are the same essentially as an Allen charge, which is keep deliberating, you need to reach a verdict. In conclusion, there is a real possibility that police arrested and prosecuted the wrong person in this case. Jamil Davidson's conviction should be vacated for insufficient evidence, as argued in the brief. In the alternative, he should receive a new trial because the evidence obtained from the misleading search warrant should have been suppressed, and the trial court's conduct involving the holdout juror was coercive. Thank you.
Thank you. Case is submitted. Thank you, counsel, for your good argument. We'll sort of sit at ease.